All right, Dave Ehrenberg, who's actually not too far from Mar-a-Lago, is joining us. He's a state attorney for Palm Beach County, and Elliot Williams is a former federal prosecutor and CNN legal analyst. Gentlemen, welcome. Elliot, let me start with you. The former president invoking his Fifth Amendment rights here. This has gone on for now hour 6. We hear from Karis Connell out there. Is this what you expected that he would do, knowing his history in these depositions?
Yeah, I think so. So it's a few things, Victor. Look, what the Fifth Amendment is, it just says in the Constitution quite clearly that no person can be compelled to testify against themselves. You can't bring someone in to have them testify and then use that testimony in a criminal proceeding. And so you hear, literally, you have the right to remain silent. If you've ever watched a cop show, that's the Fifth Amendment. That's what the president asserted here. Actually, he's got a basis for asserting the Fifth Amendment here because we know about an ongoing criminal investigation in New York City based on the same facts that the Attorney General is investigating today. This question of whether he unlawfully inflated the values of some of his properties. So, yes, we could have expected it, but this might be the one time Donald Trump actually has a good Fifth Amendment claim to bring.
Dave, this is a financial investigation, right? They're trying to determine if he inflated or deflated the values of properties for insurers or other business contacts. These cases are made on paper. So how detrimental, maybe, is this to the case or not?
Victor, it's hard to tell because when it comes to these economic cases, people lie, but paper doesn't. And that's why you want to find the paper trail. But Trump doesn't use email or text messages, so that's why they wanted him to testify, and now they're not going to get it. But because this is a civil investigation, Donald Trump's taking of the Fifth Amendment can be used against him as a negative inference at a civil trial. So Trump was caught in a box here because if he took the Fifth, then he avoids having his statements used against him in a criminal trial. And there is a criminal investigation, as Elliot pointed out. But at the same time, he risks having the invocation of the Fifth creating a negative inference against him in a civil trial. So Tish James, the Attorney General here, is going to use that against him. And if you don't think a civil investigation matters, just ask Ivanka. The Trump Foundation was shut down because of an action taken by Attorney General Tish James, the same person who's in charge of this.
Now, Dave, you said that this could be used as a negative inference against him in a civil trial. Do you expect that this will go that far to a trial?
These things rarely go to trial. They usually settle, just like the Trump Foundation. They agreed to disband the whole foundation. And I expect this to settle, but I do expect that there will be an action brought against Trump and the organization by Tish James. She's come a long way to get this deposition. I think she's going to keep pursuing it till the end. The bigger question is whether it leads to criminal charges. My counterpart in Manhattan, DA Alvin Bragg, has sort of put the criminal investigation on hold. There was a lot of controversy about that. And Trump was worried that if he said the wrong thing, it could reignite that criminal investigation. Well, I think he doesn't have to worry about that as much as he has to worry about civil charges coming.
Yeah. Elliot, what do you make about the disparity in strategy here? Because we know that the former president is invoking the Fifth. Also, his son Eric Trump invoked the Fifth. So has Alan Weisselberg, the CFO of the Trump Organization. But Donald Trump Jr., Ivanka Trump, answered questions. I mean, Eric Trump and Donald Trump Jr. are both leading this organization, or at least they were during the administration, taking different roads. What do you see here?
Look, there's this open question as to whether the president is playing four-dimensional chess while everyone around him is playing checkers, and there's a grand strategy here. I'm not convinced that they actually have a broader grand strategy here legally, and it is splashy to plead the Fifth. And if you notice, the president immediately came out and issued a statement saying, I plead the Fifth a bunch of times. This is the fake news media coming after me. It is probably as much of a political and public relations strategy as it is a legal one, notwithstanding both of the legal points both David and I have made here. I think there's a little more behind this than just legal strategy going.
Dave, let me ask you about the search warrant that was executed on Monday at Mar-a-Lago. There is the return. There's the inventory of everything that was taken. If this is so egregious, as the president and his team say that this was, Should the former president make that public?
Oh, yes. And the former president can. He can release a search warrant. He can release the inventory, but he's not going to do so because he knows that'll undermine his claim that he did nothing wrong. And I think this claim that the DOJ should be the one that's transparent. You saw when Mitch McConnell said that, hey, let's talk about this in public, Merrick Garland, and give us more information. Well, he knows that prosecutors live by a different set of rules than politicians. We cannot provide details about a pending investigation that could jeopardize our sources, that could jeopardize our case, because you're depriving a future defendant of the right to a fair trial if you litigate it in the press. But the potential suspect here, Donald Trump, is not subject to those same rules. He can release all that stuff, but he won't, because he would rather try this case in the court of public opinion.
Dave Aronberg, Elliot Williams, thank you.